It's a pleasure to meet you.
Pleasure to meet you too, Andrea. Thank you for inviting me.
Oh, thank you. It's a pleasure. If you don't mind, I just wanted to briefly provide an introduction of your biography and to say hello to all of our participants today in our audience. Hello, good afternoon. Thank you all for joining us today for this presentation titled The First Amendment in Libraries with Deborah Caldwell-Stone. My name is Andrea Valencia, and I am the User Experience Librarian here at the Riverside County Law Library. I want to thank you all for joining us today. This event would not be possible without the support of Deborah Caldwell-Stone, the American Library Association, and the past and present Riverside County Law Library staff members. Deborah Caldwell-Stone is the director of the American Library Association's Office for Intellectual Freedom and executive director of the Freedom to Read Foundation. For over 20 years, she has worked closely with library professionals and library trustees on a wide range of intellectual freedom issues related to library service in the United States. She has served on the faculty of American Library Association sponsored Lawyers for Libraries and Law for Librarians workshops and is a contributor to the 10th edition of the Intellectual Freedom Manual. She has contributed articles on law, policy, and intellectual freedom to the American Libraries and other publications. It is my great pleasure to introduce her to you today, and I look forward to hearing what you are going to share with us.
Okay, thank you. I've signed in a second time to have my desktop available. I am going to share some slides with you, so let me get those going. And actually, I need to do one thing here. All right. So let's see, has that come? There we go. Again, thank you for inviting me to talk to you today about libraries and the First Amendment. And I do have to make a note. I'll be talking about basic legal concepts about libraries and the First Amendment. I have to caution you that this is not legal advice and you should not use it in place of legal representation. And it doesn't constitute a legal opinion. So I was asked to talk about intellectual freedom from the perspective of libraries in particular. And I have to say that intellectual freedom is one of the core values of the library profession. Librarians take their commitment to providing access to information and ensuring that individuals have free access, equal and equitable access to information very seriously. And in the United States here, we treat it as well as a fundamental right. And so we've approached intellectual freedom from a number of ways, but essentially we protect the ability of anyone to look for, find information in the library that it makes available, and that information that's provided through the libraries is information that represents a wide range of views and ideas, so that the individual reader can make their own choice about what to read. Make sure that they have a deep pool of resources to choose from so that they can think about things, make up their own mind about crucial issues or even inconsequential issues in their lives, and decide for themselves what they believe and think, and then have the ability to act on those beliefs in accordance with support for our constitutional democracy. Now, the First Amendment in the United States generally protects the citizens from government restrictions that place a burden on the right to speak, the right to publish, the right to hold or not hold a belief. And this does include a right to receive information. Even though the First Amendment does not mention a right to receive information, the Supreme Court has consistently found and protected the right to receive information as an essential element necessary for exercising all First Amendment rights. So in the library context, the publicly funded library context, it's the right to receive information that is protected under the Constitution and the First Amendment. Now, I want to take a little side trip to talk about public fora, because it's important in our discussion of what the First Amendment does and affects the public library. As you know, there are three kinds of forums: a traditional public forum, a designated or limited public forum, or non-public forum. And the traditional public forum is just what it is. It's the public square, the town commons, the public sidewalk. It's a place where free speech has been traditionally protected from time immemorial, and where anyone can engage in any expressive activity subject to certain time, place, and manner restrictions. Now, designated or limited public forums is property that the government has opened for expressive activity by part of the public or all of the public. And it's a forum where the government can actually designate a forum for just certain expressive activities. And the thing to remember is that both traditional and in designated or limited public forums, the government can't impose restrictions on speech activities based on its content or viewpoint. And in a limited forum or non-public forum, the government agency administering the space is only obligated to allow those First Amendment activities that are consistent with the nature of the forum, even if the facility is open to the public. And as I mentioned, the government may impose valid time, place, or manner restrictions, even in a traditional public forum, provided that those regulations are content neutral, narrowly tailored to serve an important, significant government interest, and leave open alternative communication channels for communicating a speaker's message. Now, courts have determined that public libraries, publicly funded libraries, are designated limited public forums for the right to receive information. And to unpack this a bit, government facilities like libraries are considered to be limited public forums for purposes of the First Amendment. In limited or non-public forums, the government agency administering the facility of the institution is only obligated to allow those First Amendment activities that are consistent with the purpose and nature of the facility, even, as I mentioned, if the facility is open to the public. And so this does have implications for library policy addressing user behavior and user access. And some of the time, place, and manner restrictions that could be used by a library are regulations on the hours of operation, disruptions in the library, costs for copying, time limits on the use of materials or library services, capacity for the use of meeting rooms, and policies addressing user behavior. But the important thing to remember, publicly funded libraries as government entities are subject to the provisions of the Constitution and the Bill of Rights and must operate in compliance with the Constitution and the Bill of Rights. And this does include the First Amendment, including the right to receive information. So public libraries are public forums for access to information, but I want to get into this a little deeply because there were some questions that were posed to me about what can take place in a library as far as expressive activities. And so the library is not a public forum for engaging in other expressive activities unless those activities are expressly authorized by the library board or the library's governing body. So traditional free speech activities, such as making speeches, distributing pamphlets, gathering signatures on petitions, and similar activities are not protected when they occur are not protected in the same way in libraries as they are protected when they occur on public squares or on public sidewalks. So publicly funded libraries can adopt reasonable policies to regulate expressive activities that are not part of its mission, including activities such as filming or photography. And they can regulate behavior that impairs the operation of the library, such as the harassment of other library users or the harassment of library staff. I would like to offer a non-library example. For example, courthouses are open to the public, and the public makes use of the services available in the courthouse. And in most cases, the public can enter the courthouse to observe trials and sit in the public gallery. But when courts of laws have examined the status of the courthouse as a public forum, they've actually decided it's a non-public forum. And so they rule that the courthouse is a place where the government can control the user's expressive activities. They can forbid photography or filming inside of courtrooms or the courtroom itself, even though the public may enter and view activities in the building. As you recall, the Supreme Court itself famously forbids the use of cameras in its courtroom. So, libraries are entitled to place restrictions on user behavior, user activities in the library, especially when it's intended to protect the ability of the library user to make use of library services in an undisturbed fashion, to protect their privacy, and to, in fact, protect the staff from harassment. Now, I want to talk about book censorship and the library as well. Once libraries make, I'm sorry, it's the slide, has the slide changed, excuse me. I am sorry, I have not been changing my slides for you, and I have to apologize for that. I am so sorry. But I think we've caught up now. I'll make the slides available, of course, after the presentation for your use. So once libraries make information available by placing a book on the shelf or providing access to a platform or information resource, courts have found that removal of the material must meet First Amendment doctrinal tests, because removing or restricting material that impairs a library user's access to books and other resources can constitute the abridgment of a library user's First Amendment rights. And restrictions on receiving information from the library are unconstitutional if they place an outright ban on receiving information or impermissibly burden the ability of a person to receive information. This can include the relocation of books already in the collection to another area of the library if it's done to prevent the intended user from seeing or borrowing the book. This also includes moving books from the children's collection to the adult collection if the intent is to restrict access to those materials for the intended user, that is, the child user. Now, no government entity, including public libraries, may restrict or censor materials because of the viewpoint expressed by the author. And if a public library removes any book because it disapproves of the content of the book, the library must show that the decision can meet the requirements of the doctrinal legal test called strict scrutiny. As many of you know, to do this, the library or school must produce evidence demonstrating that there is an compelling interest in removing the material, and that the goal of removing the material is narrowly tailored to achieve that compelling interest. And of course, this is a difficult test to meet. Courts, including the Supreme Court, almost never find that a library or any other government entity meets this test if the government's actions result in content discrimination or viewpoint discrimination. In addition, if materials are removed in violation of the library's own written policies, not following that policy is considered by courts to be a major indicator or substantial evidence to a court of law that there's an unconstitutional motivation for the removal of the books. It means that the decision to not follow policy itself can result in legal consequences for the publicly funded library. And one other note, if it can be shown that the removal or restriction of library materials was accomplished for a discriminatory purpose or a politically partisan purpose, it could be overturned in a court of law as a violation of the library user's First Amendment rights, even if on its face the restriction appears to comply with constitutional requirements. Now, there is a leading text case that comes out of Texas that illustrates the limits on a government's ability to remove or restrict access to public library materials. This case, Sun versus the City of Wichita Falls, was decided by the Federal District Court in North Texas, and it overturned a city council ordinance that was designed to allow individuals in that community to restrict access to materials in the children's room. The gist of the ordinance was that any 300 people could sign a petition mandating that a book be removed from the children's collection and placed on a restricted shelf in the adult collection of the library. And their reasoning was that, well, the book was still in the library, it was still theoretically accessible, and that if a parent wanted a child to read the book, well, they could go sign the book out of the restricted area of the library. And of course, adults could ask, what was the problem? Well, the court saw enormous problems with it. The court ruled that in authorizing any 300 people to place a restriction on a book based on moral, religious, or political objections to that book, it was impairing the First Amendment rights only of adult users in the library, but minor users as well. And that restriction, because it effectively prevented the intended reader, the child reader, from accessing the books, was an unconstitutional burden on the First Amendment rights of the child library user, as well as the adult user who wanted to read the book. The books in question, by the way, were two picture books. Heather Has Two Mommies and Daddy's Roommate. So there was no argument that the books were in any way inappropriate for minors. They were both age appropriate and developmentally appropriate, other than the fact that they were addressing the fact that there are families that are headed by same-sex couples, which a church in the community had objections to. As a result, the court in North Texas overturned the removal of the book, ordered the books back into the children's browsing collection, and struck down the ordinance as unconstitutional. Another issue that has recently come up for libraries that I know that there's some interest in is First Amendment audits in libraries. Individuals going into libraries and asserting that they had a First Amendment right to film anything inside the library because it's publicly funded, because it's a government entity. And it's not just libraries that have been targeted by these First Amendment auditors. They've gone into city halls, they've gone into classrooms, they've gone into welfare offices, they've gone into driver's licenses facilities. More famously, they've gone into police stations as well, or filming police carrying out their duties on the street. But we're most concerned from our perspective about the use of First Amendment audits in libraries, because that can have significant disruptions to the ability of library users to use the library, and disruptions to the ability of the library staff to serve the needs of their users. Now, the right to make an audio or audiovisual recording of public activity is a right protected by the First Amendment. We have to remember that in the first instance. And the guarantee of the right to record is a corollary of the right to publish the resulting recording as a journalist, as a creative person. So the First Amendment does protect the right to film or take photos when the person is filming on a public street, on a public sidewalk, in a public square, or in a public park. But it only provides full constitutional protection to recording activity, filming activities in a limited or non-public forum when those activities are consistent with the mission or purpose of the facility, or there's written policy that expressly allows that activity in the facility. So the First Amendment does not guarantee the press a constitutional right of special access or a right to film in spaces not traditionally preserved for use by the public. So, as you know, the press is traditionally and regularly excluded from grand jury proceedings, courthouses, the meetings of official bodies gathering an executive session, and the meetings of private organizations, or places reserved for the use of a particular group or a particular person. As I mentioned earlier, courthouses are non-public forums. And most courthouses forbid photography or filming inside of courtrooms or the courthouse itself. Um, uh, with other facilities, for example, I mentioned that we've had First Amendment auditors enter into welfare offices, asserting a First Amendment right to record a person's personal information, their act of applying for public assistance. And that has been rejected as well. An individual also entered into a city hall and went into various offices accomplishing various government activities, whether it was streets and sand or recording real estate titles, other activities that are traditionally part of City Hall services. And again, there's been a ruling that was not an area where the right to record was protected. So the most important consideration for public libraries in this regard is protecting the library user's ability to use the library, confident in the knowledge that their library use will not become public knowledge. So even, and certainly libraries are public places. You can't prevent anyone from observing someone in public, but you can strive to protect library users' privacy when they are using library resources. You can protect the ability of a library user to pose a reference question and the subject of their inquiry from unwanted scrutiny. And certainly you can protect library staff themselves from harassment by individuals when their activities are disruptive or interfere with their ability to deliver library services. So I will tell you that often First Amendment audits can be unobtrusive. They come in, they film the lobby of the library, they film staff at the information desk, at the checkout desk. And they film activities at a distance. And this is non-disruptive activity. The library is a public space. And that's the kind of filming that could probably take place in a public library or a publicly funded library without much restriction. However, we do receive reports from libraries across the country of auditors entering, these self-described First Amendment auditors entering public libraries and insisting that they have a right to put a camera in the face of a staff member and insist that the staff member answer questions, or to follow staff into private staff areas, or to record what someone is, library user is viewing on a computer. And that is absolutely not true. There is no protection for that kind of harassment, that kind of disruption in the library. And per the court's authorities that say that libraries can adopt reasonable rules to restrict even expressive activities that are not part of its mission, it's possible for the library to craft policies that protect the library user's right to privacy, that protect the staff from harassment within a policy that addresses user behavior and prevention of disruption in the library. So we often have advised libraries that they should adopt written policies that do allow for photography and filming in the library building, and that does not invade privacy of library users. Many people visit libraries to view architecture or look at historic collections, or even want to use their phones to take photographs of texts or references that they want to take home with them. And of course, you can't have a blanket policy forbidding all photography in the library. But as I said, you can have these policies in place that address behavior that is disruptive or harassment. And so the other step we actually advise libraries to take in the context of First Amendment audits is to clearly identify non-public spaces in the library that are not open to the public, so that, for example, staff can retreat into the staff area and that there's no license or permission to enter that area. Washrooms, public study, private study areas, break rooms, and so that the library is doing all it can to balance its obligation as a public space that has certain obligations under the First Amendment to permit access and use, with the necessary role of protecting library users' ability to use the library without being harassed or having their library use become public knowledge. I do want to address one issue that has come up recently in context of First Amendment issues in libraries. We're frequently seeing these days much rhetoric that claims that books in library collections, public library collections, and school library collections are somehow obscene or pornographic simply because they touch on matters dealing with sex education, sexual health, literature that describes sexual activities between characters, or address issues around gender identity or sexual orientation. And so we've had to do a lot of work in recent months talking about what is actually unprotected speech that can be restricted or banned under government edicts. And of course, there is the traditional categories of unprotected speech: obscenity, child pornography, defamation, false advertising. And of course, the harmful to minors standard for young people that addresses what is considered obscene for minors. So, but of course, we all know that the test prescribed by Miller v. California creates a very narrow category of speech that is actually unprotected by the First Amendment, and that the work has to be evaluated as a whole, that it has to be very specific about the material that is banned, that what is offensive has to be, the sexual conduct described has to be prescribed by state law. Whether it appeals to the prurient interest. And I know that I often get questions about what prurient interest means, and I know that many of you may understand that, but what I often say to lay people is that when you're talking about prurient interest, it's a way of describing material that both is sexually tittillating, but also a little bit disgusting, turns you on and turns you off at the same time. And then, of course, whether the work taken as a whole has literary value, educational value, artistic, political, scientific value. And as you know, all three the material has to meet all three prongs of this test to be considered obscene. And even in the case of obscenity for minors, all three prongs of this test have to be hit. And in the context of minors' rights to access information, when something is determined to be harmful to minors or obscene for minors, the decision that's to be made is to be made in the context of the oldest of minors. Courts have said that if a work would be protected for a 17-year-old, for example, it's protected for all minors under the age of 17. So, we've seen this controversy over materials available in the public library, arguments that many of the books are illegal under state law that should be prescribed. We've actually seen advocacy that argues that librarians should be subject to arrest under obscenity statutes. But most of this is based on misinformation and disinformation about what the law requires in regards to unprotected speech and what's considered obscene and subject to prescription by library boards and the government itself. We'll observe that many materials that are available through booksellers, mainstream publishers, online stores, the books that do fill the shelves of public libraries, don't begin to meet the legal definition of obscenity. And I would note that few, if any, content providers, book publishers, filmmakers would risk liability under any state's obscenity statutes. So these arguments that these books are obscene, illegal, should be removed for libraries for violating state law simply don't have any foundation. So to wrap up, I do want to provide a slide, which we'll share later, with the legal cases that I relied on in providing much of this information. The first set of cases address the First Amendment right to both access a library and the First Amendment right for a user to access the materials in the library without government restriction. And then the subsequent cases deal with restricted speech and government behavior. In particular, the Nynest case is of interest, and I'll conclude with a quick summary of that case. Mr. Nynest was a member of the Barefoot Society of America, and he felt he should be able to enter his local public library barefoot. However, the Columbus Public Library had a rule, essentially, that you couldn't enter the library without a pair of shoes on. And Mr. Nynest challenged this rule. He argued that he had a First Amendment right to access the library, and he should be able to come in as long as he was clothed decently, even if it meant being without shoes. And as it turns out, the Sixth Circuit Court of Appeals here actually sided with the Columbus Public Library. They said it was reasonable for them to have a rule prescribing entering the library without shoes. And they said that because the library could show that there was a reasonable basis for their restriction on entering the library, that they had found blood, feces, broken glass on the floor of the library, they were entitled to put a rule in place that protected both the library user from being injured and the library itself from being sued for causing that injury by having, the materials on the floor, even though that objectively that might interfere with Mr. Nynest's First Amendment right to access the library without restriction. And so they upheld that rule. And so that case can be more generally applied to other behavior rules that seemingly restrict First Amendment rights to engage in other expressive activity in the library as well. Now, I'll finish with that, and I left time for questions and discussion. We do offer assistance. We do offer answers to questions and invite individuals to report censorship to us. But I will conclude with all of that. And as I said, we'll make the slides available to the audience. And I'll stop sharing my screen with that and ask if anyone has any questions or any points of discussion they would like to raise.
Thank you. I'm definitely going to be looking up all those cases and reading them shortly after this. But we did have a few questions. Someone asked, how do these rights extend to patrons viewing pornography in the library?
The guidance we received in regards, as you know, pornography has no legal definition, and while it's difficult to come, there is some right to look at materials that have nudity in them in the library, but it's also permissible for the library to govern behavior around that. So if individuals are engaging in harassment, like turning their screen where it can be viewed by others, inviting others over to see the materials, if the computer is in a public access area where it can be easily viewed by people passing by, it's permissible to have restrictions that limit the ability to use the computer for that purpose or to engage in harassment. Our best practice is, you also have the consideration of preserving user privacy. So the use of privacy screens, the arrangement of furniture that prevents screens from being observed, you want to respect the right to privacy because individuals do access materials that are sensitive, and it's not just materials that may include nudity or sexual explicit material, they could be looking up material related to hospital care, healthcare issues, even sensitive information around Social Security, job applications and things like that. So arranging the library to preserve the privacy of the user and the privacy of the user's inquiries is something that we recommend libraries strive for. And it's consistent with state law. In fact, California does have multiple statutes that protects the right of the users to protect the privacy of their inquiries. Both a library confidentiality statute that applies to library records and a right to read statute that was more recently implemented by the California legislature. You can have rules in place that bar viewing child pornography, materials that have been declared obscene, and to control user behavior when it's disruptive or active. And that relies on internet use policies. And so every publicly funded library should have a good internet use policy in place, not only to address behavior issues and protecting the quiet, what we call the quiet enjoyment of the library for other library users, but also to protect the library itself from liability. I don't know if anyone's aware of a case that took place in California. I can provide that. It's not part of the citations here, but I can give it to Andrea later. But a mother actually did sue a public library in California when her 12-year-old son used the unfiltered library access to access nude pictures that he printed out and brought home with him. And she allowed her son to visit the library unsupervised. So he visited the library, used the computer, printed out a bunch of, what we would call pornography and took it home. She discovered it hidden in his room. And she sued the library, arguing that the library had a duty to prevent her son from accessing those materials, had a duty to supervise her son in the library, and had a duty to prevent pornography, however you want to define obscenity, child pornography, from entering the library by putting filters in place. And in fact, the California Court of Appeals rejected all those arguments and said by putting an internet use policy in place, the library had protected itself because the policy contained a provision that warned parents that there were materials on the internet that they might not want their child to view, that some of those materials included sexually explicit material, and that it was the parents' role and duty to be with their child at the library if they were concerned about that library content. That was one part of the internet use policy. So the parent had been warned that, and the other part of the policy warned parents that they would not supervise the use of the library and that the library's internet was unfiltered. And so with those provisions in the internet use policy, they found that the internet use policy had provided sufficient warning to the parent that they had to take responsibility for their own child's use of the internet. Another finding of the Court of Appeals, I don't know how many are familiar with Section 230 of the Telecommunications Act, but this is the very broad provision that protects any entity that provides access to the internet without providing content itself, protects them from assuming liability for the content provided by third parties on the internet. So if somebody mounts a website that contains libelous statements, for example, and someone would access that through the library's public access computers, the library could not be sued for publishing that libel. Section 230 protects them from that third-party liability. And the court also said in this case, Kathleen R. versus the City of Livermore Public Library, that Section 230 also relieved the library from liability for third-party materials published on the internet. So it's a case to be aware of, particularly in your jurisdiction, because it does provide guidance and protections for the library providing open access to internet use that will support both protect the library and protect the library user's right to access that information. Is there another question? I'm sorry, I don't have the chat up anymore.
Yeah, you make excellent points though, because you can't really define
pornography.
pornography, and plus when you come into, once you start thinking about images versus videos versus websites, of course, you know, you can get around those things and pull up different things. So of course, especially, you know,
Mhm.
you can get around it. Um,
And it's difficult, and
yeah.
as I said, you can have policies barring access, obscene material, and child pornography because those are illegal materials and they're unprotected.
Mhm.
Fact is, the devil in the details, of course, is how do you apply that? Child pornography is there's no question. It's not hard to determine what is child pornography. Images that include actual children being used in sex acts, that's prohibited. And absolutely, we advise libraries to prohibit that and to call police when someone tries to access that material. But it's a far harder call when so many, you can access movies that were designed for cable viewing or theater viewing now and stream them on library computers that include nudity, that include sexually explicit scenes, but that's protected by the First Amendment. And do you prohibit access to those films, those videos, many of which are award-winning films? The same argument with award-winning literature that contains challenging content. I think of Toni Morrison's Beloved or The Bluest Eye as examples of works that unflinchingly deal with sexual assault, sexual abuse, and the impact on the victims, and the impact of slavery that have been controversial. But we don't bar them because they deal with sexually explicit, they have sexually explicit materials in them. We protect the right of the user to make those choices and to read that material. And then have in place reasonable policies that alert parents to the need to supervise their reading, but also state that libraries are willing to work with parents on guiding young readers to materials that suit the needs and values of a particular family, so that we can continue to make a wide variety of materials available to everyone in the community.
Mhm. Looks like the next question is a little broad. It is the right to receive information limited to certain types of materials, such as books? What about music, visual arts, dance? Similarly, are there obscenity standards limited to types of materials or expression?
There's no limitation based on the genre of format that is used to communicate a message. So if what libraries have discretion over is curating their collections. But once it's in the collection, the First Amendment applies with full force. And I would say that the obscenity standard to be applied is very limited. You know, I'll be an advocate here and say that librarians are engaged very thoughtfully in their collection development. They have policies, they have objective standards in place. They don't collect materials that are obscene on purpose, or they are collecting materials that serve the information needs of someone in the community. And that can take many forms. It could be film, it could be music, it could be print, music, sheet music, if that's the nature of the library. It could, I know that libraries are offering hotspots now. And in that regard, you couldn't restrict access to the hotspot because of someone's background, because of someone's identity or anything like that. That was the markers of discrimination, but and that's how the First Amendment, and I'm going off on a side point there because that gets more to the access to the library rather than the ability to find, read, and discover materials in the library. But to sum up, it doesn't matter what format the information is in. It doesn't matter what genre it's in. If it's part of the library's collection for use of the library user, it's protected by the First Amendment, and all the First Amendment standards would apply. That includes the prohibition on viewpoint discrimination, or viewpoint on content discrimination, and the very narrow prescription on materials considered to be obscene under the law.
We have one more question from the public, and then I had one question I wanted to ask myself. So I'll ask the question from the public first. It's a little long, so bear with me. It is, I've heard that forcing a group that has booked a meeting room to open the meeting to the public would be an infringement on the First Amendment rights of the person who has booked the room. Is this true? And is this true? And is there any difference in whether the group is paying or not? We have had some free meeting rooms and some that have fees. Our policy is written so that the free rooms should only have meetings that are open to the public. Is this okay?
So there's a lot to unpack there. And I didn't address meeting room issues. And I will say that some of the robust legal authorities that are out there, the longest line of precedent actually around libraries in the First Amendment deal with meeting rooms. And so some basic fundamentals. A library cannot discriminate against a user group because they're going to be talking about a religious topic or political topic. If they are a user otherwise entitled to come into the library and use the meeting room, the topic of their conversation is not grounds for denying them access to the meeting room. Similarly, you cannot deny access because they belong to a particular group or are of a, have particular background, particular political views, basic non-discrimination principles. All right. After that, it's up to the library. A library, because meeting rooms are not traditionally part of the mission of a library, the mission to provide access to information, they're not obligated to provide a meeting room. And so it's only by the library board, the governing body's choice, that if they want to open space for meetings to the public, they can. And then, as I said, the non-discrimination principles kick in based on identity, topic, whatever, viewpoint, discrimination. As far as requiring the meetings to be open to the public, that's actually a requirement a library can impose for free use of its meeting rooms. It's, because it's not there's no protected First Amendment right to have access to meeting room space in the library. That's a grant given by the library board, subject to its reasonable prescriptions. Then, it's libraries have often required that in order to use their public meeting rooms, that you have to allow everyone in the community access to the meeting. It's not a First Amendment infringement on the organizer's rights. The organizer has a right to use the resource as it's offered by the library, not to dictate how they can use the library's resource that's provided. In this case, the resource is the meeting room. Now, fees, no fees, that's a different kettle of fish. There are some libraries, particularly large urban libraries, that maintain spaces for rental, for private use. And they actually do that in some ways to better control access, because they can deny a rental contract if they don't want to rent that space to a particular group. So it becomes a very complex issue to address. Fees can be charged. The way we look at it with regular meeting rooms, libraries can charge fees for having to have the meeting room open off hours, a security guard, or if there's janitorial services involved or IT services involved, like the microphone or access to the internet to project on, for sharing slides on a screen or something like that. Libraries could charge reasonable fees for that, even in a free meeting room. Many choose not to, because they don't want to create unreasonable barriers for groups that may not have the same amount of money as other groups to use those resources in the meeting room. But rental of space does raise a whole other kettle of fish. And the library administration can create a rental contract that places restrictions on hours of use, when the meeting closes, and things like that. But there might be more liberty attached to the rental room. So to sum up here, you have to distinguish meeting rooms that are provided to the public as a public resource. And in that case, the library cannot engage in any kind of content discrimination, viewpoint discrimination. They have to offer the room on the same terms to everyone in the community. And there can be reasonable fees charged where there is a cost for set janitorial services, IT services, and things like that. It's not unimaginable for a library, especially libraries like with historic spaces or unique spaces, to have a rental space. And that's subject to the rental contract and as well. There could be an argument that there is First Amendment right to have the same terms as any other rental person. That's not something that's been litigated yet, but I would recommend that libraries that are engaging in room rental engage. This is not something you should just do casually. You should engage the services of an attorney who's familiar with these rules, both under federal law and state law, and make sure that you have a contract that can be enforced in court.
We have one more public question that popped up. Gender Queer, which is a book title, Gender Queer, has been banned in a few children/teen libraries for including pornography. Because it is illustrated, this has caused several parents in my area concern over a single page/scene in the book. How is a book like Gender Queer protected by the First Amendment? And what could I tell parents in my area regarding graphic novels?
Graphic novels have always posed more difficulty because, images communicate much differently than words on a page and have more impact on the user. And so they've always been a challenge, but that does not mean they're unprotected by the First Amendment. In fact, genderqueer is protected by the First Amendment in its entirety. And there should be no restrictions placed on it because someone has decided that it's, quote, pornography if they're publicly funded. If they're a publicly funded library. School libraries have a little more discretion in this area. They're non-public forums. They serve a particular constituency, and school boards do have a little more discretion over what goes on in the school library. They're still bound to protect students' First Amendment rights and students' right to access materials in the library. And if they are removing the book because they don't like the ideas in the book, the viewpoint of the author, they believe that it has no educational value. The PICO decision, the Board of Education v. PICO decision that struck down an attempt to censor books in a school library, said that the school board can exercise that discretion. However, I would argue that genderqueer does not meet the criteria for obscenity. It is, as a whole, it is a memoir of one person's struggle to understand their gender identity and how their path to adulthood, and should be treated like any other memoir. And in fact, it's been litigated. There was an attempt to have genderqueer declared obscene in the state of Virginia, and the court rejected that claim. They said under either federal law or Virginia state law, which was the law applicable in that case, genderqueer did not begin to meet the criteria for obscene content or for either adults or minors. And so it's fully protected under the First Amendment and should be treated as constitutionally protected material. When a decision is made to remove a book from a library, often you can appeal that decision to the library board and encourage them to unban the book, return the book to the collection. But you may find yourself in the same place as the citizens of Wichita Falls. I talked about the Sun versus Wichita Falls decision. And there are, in fact, a number of lawsuits right now. We know that there has been an incredibly well-organized campaign to censor a large number of works that deal with gender identity, sexual orientation, and race recently in the United States. And there are a number of lawsuits attempting to vindicate the ability of the library user to access books that have been declared pornographic in the library, including genderqueer. There's a lawsuit currently pending in Llano County, Texas, where the public library removed genderqueer from the collection. And another lawsuit against a school board that removed the book Fun Home, another graphic novel, from their high school library collection. And we're awaiting the results of those cases. But the litigation that took place in Virginia Beach is very instructive, and I can share that opinion with Andrea so she can share it with you all. But, by any standard, genderqueer should not be considered obscene or illegally pornographic. There could be decisions made about where it's housed in the library. Certainly, I'll be the first one to tell you that it was written for adult readers. And it was, when it was designated as a book that might be of interest for young adults, it was intended for the oldest of adolescents. So it could be a book that's housed in the adult graphic novel collection of the public library, rather than, that could be a decision that's made by the library as it collects this material. But it shouldn't be barred because someone believes it's pornographic.
And then my final question for you, many of the participants here today come from many different types of libraries, academic, public, law. I myself have worked in both public and law libraries. What is something that you hope is universal that we all can take away to our specialized libraries?
What I would hope you take away is that it's really part of, in terms of every life. Here's what to take away. I think it's the role of every library professional and every library to preserve and protect intellectual freedom. It's the foundation of our constitutional democracy, but it's more than that. It's evidencing the respect for the dignity and humanity of every individual who enters the library to use it. And it should be the foundation for all that you do, whether you are a public library, a school library, an academic library, a law library, and making sure that your policies, your procedures are all designed to protect the intellectual freedom of your users, their dignity, their humanity, their right to access, their right to make their own choices, make up their own decisions about what to read, and to provide information with the idea that you're providing a wide range of resources so that they can improve their lives, improve their education, carry out their duties, construct a better legal case, discover a rule that governs their the title to their property that will allow them to litigate that issue, if you're a law library in particular. Academic libraries, supporting the academic enterprise, protecting academic freedom and the ability to inquire freely in places that may be unorthodox. And that's what I would ask everyone to take away from here. The First Amendment is really a tool to protect intellectual freedom, but it's not intellectual freedom in and of itself. And so to remember what the foundations for intellectual freedom are, and to incorporate that and not just look to narrow rules of law for the foundations of the protection of individuals' right to read, is something I always hope that people carry away. So I'll finish with that. Thank you.
Thank you. We are approaching 5 o'clock. We finished right on time. Thank you so much for your time today, Ms. Deborah Caldwell-Stone. It was an absolute honor to meet you. We sincerely appreciate the opportunity to discuss this very, very important topic. Thank you everyone who participated and joined us today. My hope is that the content of this webinar was helpful to everyone, both professionally and personally, and that you were able to share this content with your library system. I hope you all have a great rest of your day.
Okay, thank you.
Thank
I'll
you.
get the materials to you as quickly as possible, Andrea.
Thank you, Deborah.
Okay.